Well, good morning, everyone. My name is Jason Castor, and I'm the Chief Business Development Officer for the law firm of Parsons, Bailey, and Latimer. And I'd like to extend a huge thanks to all of you for carving out time this morning to join us for today's webcast. It's titled, as you can see, What You May Have Missed While Focusing on COVID-19. And the focus of today's presentation will be on facilities that discharge to groundwater need to assess whether they need NPDES permits. I'd like to extend a thanks to our friends from Barr for joining us for today's webinar and putting together material, along with my colleagues from Parsons, Bailey, and Latimer. Before we get started on today's presentation, I want to go through the basics of the web format today. All of your lines will be muted. That being said, we want this to be as conversational as possible and would like all of you to utilize the chat feature to submit questions throughout today's webinar. If you could please submit your questions to my colleague, Mike Zodi, throughout today's presentation, we will do our very best to address your questions in real time. If we're not able to do so, we do have time carved out at the end of today's presentation to do a deeper dive into Q&A. I wanted to also let you know that today's webcast is being recorded, and the slide deck that you're going to see from our presenters today will be shared with you tomorrow, along with a link to the webcast recording. It typically takes about 12 hours for us to get access to the webcast recording. So that email will arrive in your inboxes tomorrow, along with the slide deck. Before I turn the time over to Mike, I want to touch on a brief legal disclaimer. Today's presentation is a source of general information and should not be considered as legal advice. If you have any questions about how this information relates to your business, you must consult with legal counsel. And now that we've got through that formality, I'd like to introduce my colleague, Mike Zodi. Mike chairs the Environmental and Energy and Natural Resource Department for Parsons, Bailey, and Latimer. And Mike, I'll pass the mic to you.
Okay, thank you, Jason, and welcome everyone to this webinar. We wanted to convene our legal experts and some technical experts at Barr Engineering and do a bit of a quick but deep dive on the Maui case, talk about the holding in the case, implications for permitting and enforcement, and the science and technology side and how those intersect. So we're looking forward to the discussion with everyone today. I will give a brief overview of the sequence that we'll go into. So first of all, Lisa Kirshner, my colleague in our Salt Lake City office that I work with a lot and who is an incredible expert on Clean Water Act, permitting, compliance, enforcement, really knows the stuff well. She's going to set up the discussion of the Maui case with the background, the holding in the case, some of the key definitions, the moving parts, and some of the history. And then from Lisa, we will shift to Doug Connell with Barr, who will help visualize the Maui case, the elements, the 7 factors the Supreme Court set up, and a technical decision tree. After Doug, who is back in Minnesota, by the way, we will have Jeff Davis out here in Salt Lake City or in Utah with Barr, who will go through some modeling and hydrology issues to try and help illuminate application of the Maui case within that field. Then I will finish up and wrap it up with enforcement risks and strategies, as my practice focuses on environmental litigation, citizen suit defense. So with that roadmap, I will go ahead and turn it over to Lisa Kirshner, who will take the next step and set up the discussion of the case.
Hello, everybody, and hi, Mike. I presume you can hear me okay?
Yes.
I'm really happy to be here. I'm glad that you can't necessarily see the office that I'm working in, but anyway, thanks so much for joining. And let me start off with a big additional disclaimer. We're not going to be able to give you all the answers today, but we can give you some information on why you should care about the Maui Supreme Court decision the decision that addressed whether in fact you need a point source discharge permit for certain discharges to groundwater that ultimately reach surface waters that are governed by the Clean Water Act. And so I always figure, you know, what are the practical implications of something that should warrant some additional focus? And I believe that anyone that has any kind of infrastructure that could potentially discharge to groundwater ought to be thinking about the issues that have been raised by the Maui decision. For example, do you have a wastewater collection system of canals and ponds? Is it possible that there's any infrastructure in leakage to groundwater that could be further scrutinized under the terms of this decision? Are you working with a recharge system? Do you have septic system discharges to groundwater? Similarly, do you have detention basins? Maybe if they're covered under your stormwater permit, that's good enough. But what about green infrastructure? What about passive wetland treatment systems that we know are utilized at many sites for cleanup activities or for compliance with permit limits? Similarly, if you've got drainage to the ground from a rooftop, let's say you mobilize contaminants, is that a point source that reaches the ground? You need to be looking for your potential obligations if that reaches groundwater and it ultimately can be characterized as reaching a Clean Water Act surface water. And of course, you know, the multitude of other kinds of facilities like tailings ponds and other kinds of storage ponds, and of course, injection wells and landfills. Next slide, please. So let's just go through the case. We will go through the facts of the case and give you all a little background, those of you that haven't followed it terribly closely. It was only just recently decided by the U.S. Supreme Court. Justice Breyer authored the decision. It was issued on April 23rd of this year. And essentially, it reaffirms the longstanding understanding that NPDES permits are required, which are the point source discharge permits under Section 402, for any direct discharge to waters that are governed by the Clean Water Act. That's no news, and that's not a surprise. What is surprising is the second part of the test that Justice Breyer authored, and that is that if you have a functional equivalent of a direct discharge to Clean Water Act waters, that also triggers an NPDES permit requirement. So as we get into the facts of the case, you'll be able to understand kind of what the implications of this could be. But suffice it to say, if you've got a direct you have a discharge to anything that could ultimately reach Clean Water Act waters, groundwater or overland flow, you need to be thinking about this test that's been proffered or decided by the U.S. Supreme Court. Next slide, please. Just let's put this in context. You may have heard about other cases, and there's been a litany of case law on this issue. But recently, and in the context of the petition for cert and the Maui decision, there were a number of other cases that were winding their way through the circuits that resulted in circuit splits and actually in the court taking up the decision, the issue in the Maui case. And they kind of, some of the other cases are emblematic of the different kinds of fact situations that arise and how courts come to different determinations regarding the same. So in that Upstate Forever case, that was the Fourth Circuit decision, there was a determination made by the court that a permit's required if you've got pollutants seeping into groundwater and then to surface water from a pipeline spill that actually the pipeline break had been fixed at the time of the alleged discharge to surface waters, but the court determined there was a sufficient connection to surface water that an NPDES permit would be mandatory. A petition for cert was filed, and then after the Maui court was decided, that cert was granted, and then the case remanded to the Fourth Circuit to make a determination consistent with the Justice Breyer's decision. In turn, the Sixth Circuit had a little different take on the matter, and this result was with respect to, in the Kentucky Waterways decision, coal ash ponds, ponds that are maybe there's a connection to groundwater and then ultimately could be a trace connection to surface water and navigable water under the Clean Water Act. And in that particular line of decisions in the Sixth Circuit, the court held that those connections were not subject to the Clean Water Act's NPDES permit requirement for a number of reasons, and we can get into that, but you can see how the distinction between the two circuits reflects kind of the differing opinions and analysis that's been applied. Next slide, please. Before I go on to the facts of the Maui decision, for those of you that maybe need just a 1-minute primer, let's go through some of the key definitions that are helpful in making sure we're on the same page. As I've already referenced, Section 402 is the point source permit section of the Clean Water Act. That's the section that requires that dischargers get permits if they discharge pollutants under certain prescribed conditions that are established by the permit. The discharge of a pollutant is very broadly construed, and it is essentially any addition of any pollutant to navigable waters from any point source. And addition also is very broadly construed. Pollutant is just about anything: solid waste, heat, sand, ag waste. Just about anything that can constitute a pollutant would constitute pollutant under the law. Next slide, please. We all know navigable waters has been a much debated term. There is as much case law on what constitutes a water of the U.S. that's governed by the Clean Water Act as just about any other area under the Clean Water Act. But navigable waters is the term of art, and those are waters of the U.S., and those are the waters to which the Clean Water Act applies. And finally, I would say that the point source definition, again, it's not just a pipe or a ditch, it's a discrete fissure, it's a vessel, it can be a concentrated animal feeding operation. It's more broadly than one would necessarily think by the plain language of the term. So broadly defined. Next slide. So let's talk about, I was mentioning that there are different cases and different analyses and different decisions. And a lot of those analyses have revolved around the distinction between point sources, what I just mentioned are discrete, discernible, confined discharges, versus non-point sources. And the legislative history of the Clean Water Act is very clear that diffuse sources do not equal point sources. The legislative history of the Clean Water Act is also very clear that states and local governments, under certain provisions of the Clean Water Act, are the entities that should be addressing non-point sources. And then to some and to many, the legislative history is also clear that the NPDES permitting program doesn't cover groundwater, that groundwater discharges to surface water are more akin to diffuse sources, non-point sources, and that there are statements in the legislative history that support the notion that groundwater, it was not intended to be covered by the point source discharge program. Next slide, please. Similarly, there's variation, but as I alluded to, many years of case law over whether pollutants that discharge to groundwater and then to surface water must have permits. They go both ways, but there's also years of permitting history. Some different permitting authorities have mandated NPDES permits for pollutant discharges to groundwater that ultimately, on the basis that those discharges ultimately reach surface water. But in all frankness, that's typically not been the case. Discharges to groundwater have not been covered by NPDES permits or the state analog of the same. Given this sort of convoluted, potentially confusing history and legislative history, the EPA in April 2019 issued an interpretative statement that was intended to clarify the agency's view regarding what the scope of the act is relative to groundwater, regardless of hydrologic connection. And that interpretative statement indicated that it is excluded from NPDES permitting, regardless of that hydrologic connection to surface water. So in that context, let's talk about Maui. As many of you have probably followed this case, this isn't news to you, but I just always find it quite interesting to listen to the facts of the case because it's, not as clear a situation as you would think to result in that kind of a U.S. Supreme Court decision. There were 4 injection wells that were permitted as Class 5 wells by the county of Maui. These are wells that manage effluent from a sewage treatment plant. The Safe Drinking Water Act is the act that is under which the Class 5 wells are permitted, and it's administered by EPA in Hawaii, so that's not a delegated program in Hawaii. So EPA issued the permits over the years, did not require NPDES permits, but in the context of NGO inquiries regarding the connection to the ocean, various evaluations were reviewed to evaluate whether the effluent would reach the ocean under what conditions. The dye study that was conducted in that context documented that it took about 15 months for at least some of the wells that are inject the effluent to travel, for that effluent to travel approximately a half mile to the ocean. As I indicated, there were lots of years of history of the Hawaii Department of Health working in conjunction with EPA and assessing the permitting obligations at the site and confirming that NPDES permitting absolutely did not apply. Next slide, please. So it was in that context when the case went against the County of Maui in the district court, and then the Ninth Circuit also determined that the groundwater was not definitively excluded from NPDES permitting and identified a test characterized as a fairly traceable test. And it was in that context that the case went up to the U.S. Supreme Court. And the decision from the court determined that the Ninth Circuit test was overbroad, but instead proffered a new test that we already referenced as the functional equivalency test, meaning that if you look at the discharge to groundwater and it's equivalent to a direct discharge to surface water, you'll have to get a permit under the NPDES program. And the court identified certain factors, and it's not an exhaustive list, and they were very clear to state that, but they indicated that the time of travel and the distance from Clean Water Act waters would be most important most of the time in evaluating whether you need to get a permit for your discharges, for example, to groundwater. There are other factors that are also involved, and I believe other speakers will refer to these as well, but including what kind of material the discharge travels through, whether there's chemical alteration, like, for example, if the amount of pollutant that enters the water at the point source or groundwater is the same as what ultimately shows up at the surface water. I mean, there's a whole laundry list of factors that can be considered. And as you already, I'm sure, have surmised, none of which are definitive and will require careful evaluation from a technical and legal perspective. Next slide, please. And I guess here's some thoughts before I turn it over to the Barr folks. I thought Justice Alito's comment in the dissent was quite interesting, and it was kind of what I was thinking as I read the case, in all honesty. And he said, if the court is going to devise its legal rule, like this test, it might at least adopt rules that can be applied with a modicum of consistency. You can only imagine that if you've got a multitude of factors and a multitude of fact situations, there's going to be lots of different outcomes. And the uncertainty is only, in my mind, going to persist. All of us that have worked in the Clean Water Act just can't help but think of Swank and Rapanos and the significant nexus test for defining the scope of Clean Water Act waters, which, as we know, has really not been provided the regulated community or the regulators with much certainty, because every case is different and every situation is very specific. So I guess the question is, that also raises, of course, some other issues that come to mind that I'll just throw out there. what if you have a discharge to groundwater that then ultimately reaches in ephemeral water? And let's say the Navigable Waters Protection Rule, which is slated to be effective in June, becomes effective and ephemerals are no longer jurisdictional. What happens with this test under that situation? How does a regulated authority identify NPDES permit conditions for discharges to groundwater that ultimately reach surface water? What water quality standards apply and how are they calculated? How does one do a reasonable potential analysis to evaluate what constituents, in fact, ought to be conditioned and limited? Do the technology-based standards apply at the point of discharge to groundwater? Where does one monitor? I mean, these are just practical questions that I'm not sure, what the answers are to, and probably many others aren't as well. So what is the possible path forward? Maybe we will get guidance. I know the EPA administrator at least a week ago indicated that the agency was still digesting the opinion. And I've talked to at least several states that have indicated the same. Could there be a general permit that could apply in certain circumstances that could streamline this? All of this is just to show that I believe we're only at the beginning as opposed to the end. And I think it's going to be really critical to have a strong technical team if you have to get into this analysis to help you support your position, whichever way it may be, with some credible information. And with that, I'll turn it over to Doug to give you a little bit of insight on that.
Coming through now?
There you go.
Good. Well, hello, everyone. Doug Connell here, speaking to you from St. Paul, Minnesota. And I'm going to talk a little bit more about this functional equivalence idea and some thoughts on, what kind of factors look more like that discharge and which would position you to say, no, it's not. Start with this decision tree, and as Lisa talked about, you may have a feature with the groundwater discharge. Can it be construed as a point source? And is there a navigable water nearby? If you get both of those as being yes, is the discharge material? In other words, is it significant in the scale of the groundwater and navigable water system? And if the answers to those are yes, then you drop down to this functional equivalence test. So to illustrate what that might look like, kind of a conceptual view here of a facility at some distance and travel time to a navigable water. The first of those tests then is, what is that distance and what is that time? The court didn't set a clear bright line standard for that. You can look at the case with Maui of a half a mile in 15 months. In groundwater, the distance is easy to calculate. Time depends on the materials and the gradient that the groundwater flows under. Is it in a sand? Is it in a limestone or other carbonate rock? Is it in perhaps a bedrock of some sort? And this question of material has a lot of implications. Again, it controls the time that groundwater will take to flow from a point to the river. But it also, I think, has implications for how much of these materials like a direct discharge. You can think of sand, gravel as acting somewhat like a filter. Things are diffuse, as opposed to fractured bedrock or what's called karst, which is solution-enhanced carbonate rocks. Sometimes the groundwater in these situations can take a very discrete path. And so those may be situations where that looks more like, is more equivalent to a direct discharge. Another factor is what happens to the contaminants once they're released to groundwater. And this conceptually shows a groundwater plume, which in many cases will diminish because of physical changes, dilution, retardation, absorption to the aquifer material, and chemical and biological processes that can tend to transform or even in some cases eliminate the contaminants before they reach a surface water. You can also look at the situation of how concentrated or diffuse is the entry of that groundwater into the navigable water. So in some geologic settings, the entry would be diffuse, would be over a wide area, whereas in others, for example, in a karst or an area of fractured bedrock, those discharges might be concentrated and might be fairly discrete. Finally, the comparison of the discharge to natural conditions is a consideration. As shown here, for some naturally occurring substances like chloride or sulfate, as the plume travels and is diluted, it may reach background concentrations. In other words, the concentration being no different than what's in the groundwater from natural conditions. So all of these factors are going to play into this determination of functional equivalence. And some of them you can get at with available information. Others are going to be fairly site-specific, although I think typically most facilities will have some sense of the groundwater conditions, either through previous groundwater studies or even geotechnical studies that can shed some light on these factors. I'm going to turn it over to my colleague Jeff to talk more specifically about how one goes about establishing this picture and the kind of considerations that could come into that determination. Jeff?
Sure. First of all, I think Lisa and Doug have given us great questions and things to think about. And as a hydrogeologist and engineer, I'm all about visualizing and being able to use the tools that we have to understand what's happening below the ground that we cannot see. And so I think as we move forward, those kind of questions and understanding will be really important. Can you go to the next slide? So a lot of times we try to use tools to help us visualize what we call a conceptual model, our understanding of what's happening below the ground surface. And in the past, we've done physical models, but most of the time we use computers to do that these days. And here's an example of such a model that shows the complexities that may or may not exist. Here's an example of a project here in Utah. And we can take advantage of things like geophysical surveys, maps, borehole data, or holes that we might have drilled into the subsurface. And all that information can combine to create such a model. And these models, basically help us to understand what may be the process of contaminants moving into the ground to navigate. Okay, next slide. And in addition to the monitoring and conceptualizing the system, we also use computers to model what may possibly happen with contaminants as they move to the ground. And a lot of models have a lot of different parameters, and some of these input parameters are fairly well known, and some of them are not well known. And so we use these tools as our best understanding, and we're able to look at different scenarios and different values of these different parameters to give us our best understanding of how contaminants would move through the ground and their interaction with surface waters. So we see an example here on the screen where we've characterized a contaminant plume, and then we want to make some predictions of what that looks like in the future and what the concentrations may look like in the surface. And here's a pretty good example of that. Again, the idea is to take as much information that we have in our understanding and use the tools that we have to make predictions of future migration of contaminants. And next slide. We can also use our tools of monitoring and conceptualization and modeling to look at alternative designs. What if a permit is not, can't be avoided? And we have to work within the constraints or the limits of that permit. So what we try to do is minimize those impacts on the receiving waters. And we can use our tools, our modeling tools and monitoring to look at different scenarios and look at alternatives to minimize those effects. So here an example here of a tailings facility, and maybe that requires a permit for protection to a nearby body of water. And we, through the use of modeling, look at, okay, what if we do nothing? What if we put in a cutoff wall? Or what if we do other options as far as minimizing the migration of that, of the contaminants from that tailings facility? Okay, next slide. But whatever technical tools we have or understanding of the nature of the contaminants in the groundwater and where they might move and how fast they might move and what they look like at some discharge point, whatever scientific information that we have, that still has to fit within the framework of what we have here. And so I've listed some other components of that framework that, certainly going forward will influence how we permit and enforce those guidelines within the Clean Water Act. And so I've listed things like upcoming court decisions may need to be considered, and what the EPA does, and under what kind of administration and how that may change. And Lisa mentioned maybe general permits may be issued. So again, considering all of the the questions and thoughts that Lisa put forward and the ideas that Doug brought with the conceptualizing of how contaminants move through the ground, there will have to be this connection between the legal understanding and the legal pathways that get walked through with the scientific and technical background. And with that, I'm going to turn it over to Mike.
Thanks, Jeff and Doug and Lisa. Hey, Jason, can we go back a couple slides, please? Yeah, stop right there. Lisa, and I'll remind everyone, please submit questions to me, but I'm going to present one to Lisa that sort of popped into my mind. Lisa, let's look at the slide on the far right that says cutoff wall and liner. Let's say you've got a client who has the green blob that is getting close to the stream, but hasn't reached the stream, has not actually discharged. To unfairly put you on the spot, what do you think is the current then permitting obligation or requirement of the client relative to this new rule and the regulations as it relates to a potential permit?
That's what colleagues are for, right? Put their colleagues on the spot. I thought the green meant that was good. So if we assume that somehow the green represents some sort of plume, and it's not near it's near the water body, the surface water body, but it's not into the surface water body, and maybe this entity is subject to a groundwater permitting program and it's compliant with the state program. I would argue, and this is just an initial thought, but under the NPDES permitting program, and this was decided a long time ago in the Second Circuit in the CHAPO context, when you have a potential to discharge, that isn't enough to trip a requirement to get an NPDES permit. Because, as the Doug and Jeff were saying, time of travel could be amazingly influenced by the nature of the materials underground, what it's traveling through, the topography, the geology, et cetera, et cetera. I mean, maybe it'll never even get there. But I would argue under the NPDES program, it's not reaching surface water. You're not mandated to get a permit. Of course, as a business decision, that may be a different determination. But from a legal side of things, I would think that is not mandatory at this stage as we've defined it.
Thanks, Lisa. I think that gets to sort of some, let's say, a source is sitting on knowledge that, in 6 months, it's going to get there. Then where are you? Then it starts to become a more difficult situation, and ones where playing out scenarios, permitting and litigation risk scenarios start to become prime. So let's shift then, Jason, to the start of my slides, please. Hey, are you able to move it forward, Jason? Thank you. One more, please. Back one, please. Okay, there we go. So as I indicated in the beginning, my practice focuses on environmental litigation. I do enforcement defense, civil and criminal enforcement defense, administrative, both administrative and state and federal courts, permitting, defense of permits when permits get challenged, ancillary whistleblower situations in environmental cases, and so sort of a broad range of litigation focused. I work with Lisa a lot. I work with a lot of our other team members, and so this decision, while it it set forth a new test that clarified maybe certain tests similar to other tests that were being followed. It definitely has at least put the EPA flip-flopping back and forth to bed. But now where are we in terms of federal enforcement? What's EPA going to do in the near term? It's been mentioned, is there going to be rulemaking or guidance? I definitely think that is being considered. But as we all know, any rulemaking or guidance is going to get stuck in the inevitable bogging down in litigation that on any significant matter, and there will be more uncertainty regardless of when the rulemaking or guidance comes down until the litigation gets resolved, and then maybe, as we know, elections have consequences. So we're in 2020. We've got an election at the end of the year. I think in what I'm seeing and reading is, given EPA's position just prior to the Maui decision coming down, I would not expect overly aggressive enforcement from an EPA perspective, but that's no guarantee. I think it's going to be a case by case, and when pressure might mount for various reasons, either internally or external pressure, localized pressure, political pressure, there could be some enforcement on the groundwater side, the groundwater pathway that is enhanced, but I wouldn't expect significant new enforcement necessarily the rest of this year. So on the state level, I think sadly, for the way things are in our country, it could mean if you're in a red state or a blue state, and whether the state regulators are already perhaps might have your facility or a facility, certain facilities in their crosshairs on a risk to waters of the United States. But I think then it raises a question, does the state feel like it needs an additional tool to address the problem? Because as we've seen, and as many of you know, there are multiple tools already that the states have, and there may be internal state jurisdictional issues and issues around who's going to control the situation. But does the state feel like the problem is, if the state feels like the problem has gotten significant and it feels like it has an additional tool now that it might be able to use more effectively or more clearly as a result of the Maui decision, I could see some enforcement there. And again, people have mentioned general permit program adjustments. I'd say theoretically in delegated programs, particularly in the bluer states, facilities there may have higher risks. So getting to citizen enforcement, and the Maui case and the related cases, these were citizen suits under 33 U.S.C. 1365, the Clean Air Act. And you know what I think we're seeing is either citizen groups or, in some situations, neighboring properties have lost patience with what they perceive as inadequate regulatory enforcement or outcomes from regulatory oversight of a particular problem. Or there may be certain facilities that just are part of a national effort to focus on them, such as coal. But I think if you have a facility that already is sitting on an issue like this with groundwater issues that you know about that are reaching waters of the United States, but there has not been any state level or federal level enforcement, I think the case definitely increases the odds that a citizen suit notice could be coming your way. So under the citizen suit provision, you will get 60 days advance notice. So the citizen group or person, individual group, has to give 60 days of notice, and that notice goes to both the federal government and the state. And that really is your window. And I've worked with a lot of companies in the citizen suit context, and then teaming up with our technical, our Clean Water Act, RCRA, Clean Air Act lawyers, and then the consultants. If we're not already engaged, it's a crash course of figuring out and trying to map out, where is this going to go? What's an ultimate outcome that could be predicted here? If the federal government or a state government are diligently prosecuting the case already, which may be bad news for you in certain ways, but that is a bar to a citizen suit. Now, sometimes the thought is, let's get with the regulators and try to see if we can have an effective pathway where the regulators, they do have to file a lawsuit. It can't just be an administrative enforcement proceeding or an administrative consent order. The case law is pretty clear. There's got to be a lawsuit that's been filed, even though that doesn't necessarily make a lot of sense in my view, because the administrative enforcement pathways can have the same outcomes. I suppose from a citizen perspective, they may not have as much right to participate in the administrative pathway, and so, but they can join in a federal or state lawsuit frequently. So, but what's your exposure once you get the notice? Well, it's penalties and injunctive relief. And the penalties, as you know, can be quite high on a daily basis if there is an existing discharge, upwards of $50,000 per day. Theoretical exposure. In reality, that is rarely what is ordered when courts get around to if you're in the unfortunate situation of having to litigate one of these all the way to the end. But nonetheless, the penalty exposure being as high as it can be definitely shifts the risk factor. So we're going to look at ways to posture the facility, if it isn't already, in the best light possible, showing it's engaging in a good faith effort to address the problem, and it probably already has. And then we're going to mine the record to try and illuminate the good faith of the facility. But in a lot of ways, the injunctive relief may be the bigger issue. So what we're seeing in these citizen suit cases is there's a request for a penalty, but really the goal is to force additional remedial action. And the hydrologists and engineers who've already been engaged with the remedial action have been working with the regulators, working with the facility to try and come up with solutions, weighing the regulatory issues, the cost issues, cost-benefit issues, maybe political pressure or public pressure you might be getting in the press. A lot of factors can go into these cases. But on the injunctive relief side, the way I look at these is, okay, someone's asking a federal court judge to get in the middle of this and to take over the injunctive relief. My experience is generally they don't want to do that if they don't have to do that. And so if you have a pathway with a state or federal regulator you're already on, but you can enhance that pathway or improve the pathway, the court is going to want to defer if it makes sense. And you can convince the court that it's a sound, good faith effort. It may not be perfect, but I'm trying to map out and look down the road and help posture the facts and then manage the facts to reduce the injunctive relief exposure. So if we can go, the citizen suit, you get a notice. So this is sort of what I was speaking to. Can we moot the threatened lawsuit? Is there something we can do with the source and the regulators to do that? Should the source seek a permit? I mean, that's the allegation. You're discharging without a permit. Now, it's a unique scenario where you've got this groundwater angle, and it's not necessarily a great fit for the NPDES permits necessarily. But thinking creatively on how to come up with a permit that takes the bat out of the hand of the other side. I mean, that's what we're really trying to do if we don't have a slam dunk defense, but we're trying to minimize exposure. I already talked about invoking the diligent prosecution, good faith. What I see a lot of times, and it's very frustrating in our system, is the federalism and the facilities stuck in the middle, the stuck in the middle theme. They are stuck between perhaps the state and the federal government and different objectives. And then we have to try and get both sides to talk and get to the table and come up with a solution. I talked a little bit about mitigating injunctive relief. Really, at the end of the day, you're talking about what should be a regulatory solution and not a court-ordered solution. And you're going to be in much better shape if you can control your destiny than rolling the dice with the litigation at the end of the day. Sometimes there's no choice. There are economic pressures or intransigence on both sides that just will not allow it resolution. But in my view, being a litigator, it's usually the least effective and useful tool to solve a problem. Keep in mind data, investigation, and privilege issues, as I was sort of talking to Lisa there. Once you're sitting on the data and thinking about the data, think about attorney-client privilege issues. We help navigate those, and they're challenging. I see one question here. I've wrapped up my end. I see a question, and this one is going to Lisa. Lisa, in Utah, we have a groundwater program, groundwater discharge permit, anti-degradation. Do most other states have a similar program?
So I'll answer the question in two ways. Most other states have some sort of groundwater discharge permit program. And I believe many other states have a non-degradation component of their groundwater permitting program. But that's different from the anti-degradation concept that's inherent in the NPDES permitting world. But the two do often align. But I would say, you know, when you're looking at anti-deg and the way it's implemented under the 402 program, it's often a little, there's a particular way that the permitting authorities do that. And there's guidance and all sorts of details on that. And that isn't often the way the non-deg program, at least in my experience, has been implemented, or anti-deg, depending on what's called in the state. At the state level, sometimes they align, but not always.
Thanks, Lisa. And I'm going to throw out another question that maybe Lisa and Doug and Jeff can noodle on with us here. Let's say you do have a facility. Let's say you've got a tailings impoundment. There's evidence it's leaking, pretty much undisputed, and it is reaching waters of the United States through the groundwater, but you don't have a permit presently. Try and think through for us what are sort of the key challenges and issues in trying to come up and craft a permit to address that situation. Then I see another question came in after we addressed that.
I'll be brief here and see if Doug and Jeff have some additional ideas on this, but I think if you presume that that source is going to be characterized as a point source, which I think, you know, that's a presumption, but given the coal ash cases and the holding of the court, let's just presume that for the purposes of argument. There may be some of the difficulties, I think, as the question you raised is, you know, for example, what's leaking? How do you control how would you ever document, for example, the application of, let's say, the technology-based standards, and I mentioned this earlier, that would typically apply at the point of discharge? How would that ever be implemented in the concept of a leakage situation? And then perhaps, and I'll turn it over to Doug and Jeff for their views on this, there may be ways to demonstrate that, in fact, the impact of that is de minimis when it reaches a jurisdictional water, when you look at the nature of the constituents, the time it takes to get there, the material through which it moves.
Yeah, I'll add to that. I think that the facts are going to be determinative in terms of, is there significant dilution between the point of introduction to groundwater and where that groundwater eventually discharges to the river or lake? Is that in turn subject to dilution? In other words, is the mass of groundwater coming out diluted by a greater mass of river water? I think with some constituents, even mass loading considerations can come into play. There's been a lot of work done on legacy sites that aren't permitted under NPDES, but the approaches and the where to monitor and what's the standard, I think you can find some parallels, but it's a very site-specific situation, and again, it's going to depend on that balance between the groundwater flow and the mass of contaminants that reach groundwater and what the receiving waters are like.
Well, thank you. I'm going to, Jeff, did you want to go ahead and weigh in there?
Oh, yeah, I'll just quickly say, it can oftentimes escalate in the legal cases that I've been involved in over the years of my career. It easily can escalate to now you have a technical expert on one side and you have a technical expert on the other side, and the judge or the jury end up having to decide, okay, who are we going to believe? Because now both are arguing that their science is the more correct. So.
Okay, then we have a question from the audience I'll read, and then I'll take a first crack at it, and then I'll spread it around to the rest. So the question is, so do you recommend a wait and see approach, at least until we have more clarification from courts, regulators, until a citizen suit is filed? And I'm going to start with probably a maddening. It's hard to say. It's very case specific. I'll throw out some of the things I would think about, and I'd want to think about it more in the specific situation. I think one risk on the wait and see approach is you could be racking up potential daily penalties, I suppose, if you have sufficient knowledge that there is an ongoing discharge. I think it depends on how much knowledge you have, what knowledge the facility is sitting on. And then I think it depends on the relationship with the regulators, preserving relationships, what expectations may be, thinking through community reaction. If at some point there is perception that something should have been done sooner. On the other hand, there's going to need to be clarification, and I'm not sure if you went to the regulators right now today, you would have clear or easy answers. So I think there's risk. It depends on the knowledge that you have and the situation and the ongoing harm that may be alleged in the situation. At a minimum, I think I'd be sort of anticipating and planning around the eventuality and try to be ready for a quick solution. If you have, persistent issues with citizen groups that are out there, I think that also changes the factor, the assessment. So there are quite a few things I would sort of cycle through in my brain and go through with the source to answer that. But Lisa?
Yeah, Mike, just a couple thoughts. Of course, everything's so fact specific, but look for opportunities. For example, if you're working on a permit modification or a reissuance, you may be able to get some language in your permit that gives you a little bit more of a shield relative to scope of coverage. Similarly, if some of your facilities that may fall under this new nebulous test are really stormwater management facilities, maybe they're covered under the stormwater permit program, and maybe that's part of an individual permit or part of a general permit coverage. But that's the kind of analysis. There may be opportunities here to look at this as something, a condition that's already arguably covered and for which you have permit shield. Maybe not, but it's worth that kind of analysis, I think, pending further guidance from the authorities and the cases. Well, I see we've reached the noon hour. Jason's had some technical issues, so he had to sign off, but fortunately we're all still here, and whoever is out there in the electronic world, as I speak to my computer once more. But I want to thank everyone for taking the time out of their days. I want to thank Jeff and Doug at Barr for sharing their thoughts and their technical expertise and some of the visual graphics to help us visualize. And those are, very important from my perspective when it comes to educating a court and explaining these things.
So anyway, I think we're at noon. We will go ahead and sign off. Again, thank you, everyone, and feel free to reach out to any of us with follow-up questions offline. Thank you.